May it please the Tribunal. I have prepared a written submission which will be the guide for my submissions this morning. It has been 4 long days, and as much as I wish to be brief, the 2 charges that are before this tribunal cover such breadth that I cannot but take a few hours to go through the issues. I will try to keep it short. The prosecution has presented the evidence. The tribunal has ruled that there is a case to answer. This is therefore the defense that the amicus team presents on behalf of the State of Israel and Amos Yaron. No witnesses were called for this case. No witnesses were called for the defense. Now, both accused have chosen to not participate in this case. So we are submitting on their behalf as a friend of this court, this tribunal, as amicus curiae. First, we reiterate all that we have said and presented before during our submissions of no case to answer, and we adopt it as part of our closing submissions now. In addition, we now formally wish to present to the tribunal additional defense amicus bundles number 7, 5, 6, 7, and 8, which contain the documents that will be referred to during these submissions. We ask that they be marked as an exhibit, as exhibits. The issues are as follows. 1. Is Amos Yaron guilty of war crimes, crimes against humanity, and genocide? Issue number 2. Is the State of Israel guilty of war crimes, crimes against humanity, and genocide? Has the prosecution proven the above 2 cases beyond a reasonable doubt to the point that if one were to ask a reasonable man, his answer would be, of course it is possible that the accused could be innocent, but not in the least probable. And that was the standard that was adopted in the case of Dalilai. Only if that can be said, then there can be a conviction. The burden rests and always remains with the prosecution. A failure to challenge witnesses does not relieve the prosecution of this burden. Now, unlike civil trials, where if a fact is not challenged, it is deemed admitted, this is a criminal trial, and in a criminal trial, if a fact is not proven, it cannot be considered by the tribunal. Most of the witnesses have made their assertions. To highlight a glaring oversight, the witness Dr. Walid yesterday, his testimony, his statutory declaration should have been supplemented by documents backing up his claims, the facts and figures, the percentages. Now, documents that the defense amicus has, in a way, assisted the tribunal by putting it in pages 1 to 13 of our bundle number 7. Now, without those pages, and that was unfortunately overlooked by the prosecution in the prosecution's presentation of its case, Dr. Walid's testimony was a mere quoting of figures from the air. Pages 1 to 13 of our bundle number 7 grounded the testimony of Dr. Walid in reality. And of course, we trust that the tribunal can see that we were using pages 1 to 13 yesterday for an entirely different purpose during cross-examination. I will not dwell on this any longer. Alan Dershowitz, in his work, The Case for Israel, puts it like this. The truth is that I support Israel precisely because I am a civil libertarian and a liberal. I also criticize Israel whenever its policies violate the rule of law. Nor do I try try to defend egregious actions by Israelis or their allies, such as the 1948 killing by irregular troops. We can also call them paramilitaries of civilians in Deir Yassin. The 1982 phalanges, not Israelis, massacres of Palestinians in Sabra and Shatila refugee camps, or the 1994 mass murders of Muslims at prayer by Baruch Goldstein. This is found at page 12 of his book, and it has been appended to the submissions. At the back of the submissions, and it has been numbered. It is at page number 2 at the back of the submissions. Now I stand here to defend both Israel and Yaron, something which probably Dershowitz would not do. This is the defense. But before I go to the heart of the matter, allow me to cede the podium to co-counsel Dr. Matthew Wickraw to address the tribunal on some points of law which were raised by the prosecution yesterday in its closing. May it please the court.
Your Honors, I have 6 relatively brief points. The first issue, in relation to the charges brought against Amos Yaron and the State of Israel, the prosecution has listed war crimes and crimes against humanity alongside genocide for charge 3, war crimes, crimes against humanity, and crimes against peace for charge 4. The prosecution has effectively abandoned these charges in the submission offered yesterday. It has failed to identify or argue on the elements of any individual action that amounts to a war crime, crime against humanity, or a crime against peace, nor proven the elements of such crimes existed. As a result, the prosecution is effectively asking the tribunal to determine the charges as well as whether the elements of any such charges can be proven. Secondly, in relation to the submission, in the written outline of the submission, at section 2A, the prosecution points to the ICJ case, Bosnia and Herzegovina, in relation to whether a state can be charged directly for the acts specified in Article 3 of the Genocide Convention. It is important to note on this matter that in the ICJ case, Bosnia and Herzegovina, which I will refer to as the genocide case, the ICJ ruled that Bosnia and Herzegovina were not directly responsible, but attributed them state responsibility. They were not found to be guilty on the commission of genocide, nor were they found to be guilty in relation to complicity in the commission of genocide. In particular, in relation to 2B, it is argued that state responsibility can arise in regards to complicity. The threshold, however, mandates that there must be some type of positive action on behalf of the respondent. In particular, at paragraph 413 of Bosnia and Herzegovina, or the genocide case, the ICJ found that the activities were not committed by the actors or organs of the respondent. The massacres were not committed under the instructions or directions of the respondent. There was no effective control, which I will return to later, and there was no evidence of specific intent, which would have had to be present in order for the state to be held responsible on this basis. There were no, in this particular instance, there were no instructions offered by Belgrade or the Federal Republic or Yugoslavia organs to commit massacres. The threshold for complicity, as enunciated in this case, as indicated at paragraph 432, requires positive action to furnish aid or assistance to the perpetrators of genocide. The prosecution has not, in fact, proven that this was the case in regards to either the charges against Amos Sharon or the charges against the State of Israel. The third point, in regards to superior responsibility, I personally am assuming that it is superior responsibility that they are arguing, that the prosecution is arguing in the present case, because no other issue of responsibility was raised. In regards to superior responsibility, it requires first, effective command. Effective command is similar to command responsibility as adopted in the international...
Can I ask you a question?
Yes, sir.
Yes, sir. It can be superior responsibility, but if they incited or instructed, that's individual responsibility, is it not? They encourage. If the evidence, there is evidence that Mr. Yaron was working directly with the Falange person in his office as a representative, and that he encouraged them to do this. So that's responsibility. Is that not individual responsibility? Because superior responsibility is responsibility for acts that are accomplished by the underlings, for which they have control, which he should have known about. Now, maybe the prosecution will clarify it and sum it up. Maybe he's bringing both in. I don't know.
Your Honor, to my awareness, the only issue that was effectively raised by prosecution in its submission yesterday pertained to command and or superior responsibility. The issue of individual responsibility was raised by the bench. Continuing on, the second component required is effective control, which would indicate that, in which case it would have to be proven that Amos Yaron, or it would have to be proven that in the case of Amos Yaron, or in regards to the State of Israel, effective control was exercised over the Phalanges or any other non-state party in any of the acts that are alleged to have amounted to genocide. Whether or not the Amos Yaron or the State of Israel, particularly in relation to the Phalanges, whether or not Amos Yaron exercised authority to order, direct, and or punish the actions of subordinates remains in question. Again, the prosecution has not proved this element of the case. Moving on to the fourth point. In the Halilovich, the prosecution versus Halilovich decision, my apologies, before the International Criminal Tribunal of Yugoslavia, the decision issued by the Appeals Chamber on 16 October 2007 sheds further light on the notion of complicity. At paragraph 59, and I will quote, "A police officer may be able to prevent and punish crimes under his jurisdiction, but this would not as much make him a superior vis-a-vis any perpetrator within that jurisdiction. The accused must be, by virtue of his position, senior in some form of formal or informal hierarchy to the perpetrator." Essentially, this emphasizes the necessity for effective control over the actions of another, all right, and positive actions being taken in regard in order to be charged for a crime of genocide. The failure to prevent and or failure to punish is a separate issue altogether. Fifthly, in regards to the legal status of the General Assembly resolutions and in regards to ethnic cleansing specifically raised in the prosecutor's submission, firstly, the prosecutor contended yesterday that General Assembly resolutions are a source of law. This is not entirely true. General Assembly resolutions in international law are recognized as soft law. They are typically interpreted as a means by which to interpret the law. insofar as they constitute hard law, effectively binding provisions, remains questionable. Generally speaking, General Assembly resolutions are used primarily in relation to the determination of custom and whether or not obligations, erga omnes, exist and whether or not a specific offense has reached the status of jus cogens under international law. In regards to the General Assembly resolutions concerning ethnic cleansing specifically, the prosecution submitted that ethnic cleansing is equivocal to genocide. Yet, in the Bosnia-Herzegovina case, at paragraphs 189 to 190, if I am not mistaken, the ICJ ruled that ethnic cleansing is not genocide. It can be viewed as an action that gives rise to genocide, but can be distinguished from genocide on the basis of dolus specialis, i.e. intent. Ethnic cleansing, history demonstrates there are instances of murder, and that these are grievous. However, the intent behind the murder must be proven. Ethnic cleansing in and of itself is not sufficient to support a charge of genocide. Finally, point 6. The prosecution yesterday submitted in regards to the issue of mens rea, regarding statements made by Israeli officers and Israeli governmental officials regarding instances of genocide, what actions needed to be, instances which allegedly amount to genocide, and their instructions regarding cleanup operations. One such instance was mopping up. All right. In regards to genocidal intent, these statements do not reflect a specific genocidal intent and should not be read as such. In the case, again, before the International Criminal Tribunal for former Yugoslavia, in the case of Prosecutor V. Goran Jelicic, in both the appeal chambers, whose judgment was issued on 5 July 2001, and in the trial chambers, whose judgment was issued on 14 December 1999. The tribunal in that case was called upon to determine a line, to draw a line between sadism, which is essentially indifference towards the death of another human being, and genocide. Again, in trial chambers, they ruled that while the defendant was a sadist and had committed murders, 20 to 30 per day in a camp before breakfast. This was what the defendant actually required before he sipped his coffee. 20 to 30 murders in the morning before breakfast. They said the tribunal held in the trial chamber that he was a sadist. His actions were unreasonable, and he was guilty, but it was murder. In the appeal chambers, however, the ruling was overturned solely on the basis that his comments, the defendant's comments and statements to other people and other persons present, had indicated a racist intent behind his actions. Therefore, while the appeal chamber recognized that sadism is distinct from genocidal intent, they relied solely upon the threshold established by dolus specialis, which requires a specific intent, an intent to kill or destroy a group in whole or in part based solely on the individual's membership. If there are no further questions, I will conclude my submission.
Excellency, if I may draw the tribunal's attention to page 4 of my written submissions. I will continue from there. Let's start with genocide, specifically relating to the charge against the state of Israel. Now, in law, genocide is defined in Article 2 of the Genocide Convention, 1948. Key portions are as follows. any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. And E. Forcibly transferring children of the group to another group. Now, the Oxford English Dictionary defines it simply as this: the deliberate killing of a large group of people, especially those of a particular nation or ethnic group. The charge against the State of Israel is for the crime of genocide. This charge of genocide is, there's a typo there, unique. It is unique because by both definitions, genocide requires a decrease in population of the victim nation or group. That's how genocide works. You don't like a group, you kill them. You kill them in a grand manner. Now that's what the Nazis did. The Nazis did that to the Jews. That's what the Hutus did to the Tutsis in Rwanda. That's what Pol Pot did to the educated, to the wealthy, to the Buddhist monks, to the police, to the doctors, to the lawyers, to the teachers, and former government officials. Genocide means that at the end of the act, you have a lesser number of victims than when the genocide started. Simple mathematics.
Is that in the Genocide Convention or
that interpretation? That is my interpretation. Now, Your Excellencies will turn.
as long as the population rises, there is no genocide possible?
It is a logical problem.
I'm not so worried about the logic. So if I kill 10,000 people, but the population increased by 12,000, therefore there is no genocide.
Logically, that. Now, Your Excellencies, Your Excellencies will turn with me to bundle number 5, page 413. This is the progress report of the acting mediator for Palestine submitted to the Secretary General for transmission to the members of the United Nations. It states that in 1948, the population of Palestine was about 500,000 Arabs. Now this is the high figure in the report. The low figures that we have there quote somewhere either 472,000 or 360,000. If I may quote at the last paragraph of page 413, the present situation, number 4, the situation of the Palestinian refugees is now critical. This is in 1948. Your Excellencies will turn with me to page 414 at the 4th paragraph under C, item C. Thirdly, as a result of careful investigation of the numbers involved, the immense scope of the problem has now become apparent. Part 3 of the mediator's progress report tentatively placed the total number of Arab refugees at 360,000, and 2 lines under that, it quotes 472,000, and the link is C Appendix A. There's a chart in the middle there. Below that, the highlighted part, a figure of 500,000 has been accepted as the basis for calculation. Now, at the lowest portion, point number 6, the last paragraph, these figures for Arab and Jewish refugees do not include a large number of persons who have not left their own districts, but who are nevertheless totally destitute as a result of military operations. Now, from this report, the high figure is 500,000. The current population of Palestine, the Palestinians, according to the ECSWA, Economic and Social Commission for Western Asia report. Now that, if Your Excellencies will turn with me to bundle number 8 at page 41. At number 1, the first paragraph. The population size of Palestine increased from 1.5 million in 1980 to 4.0 million in 2010. It is expected that the population will keep on increasing to reach approximately 9.7 million in 2050, without belaboring the point. Our submission is that there is no genocide in Palestine. If indeed Israel, the state of Israel, is committing genocide in Palestine, they are doing a terrible job at it, because the Palestinian population is increasing. The UN says so. Now, when we talk about genocide, we talk about big numbers. We talk about huge numbers. Some of the examples. Armenia, 1915 to 1917, 1 million dead. The Holocaust, World War II, 1938 to 1945, about 6 million. Rwanda, 1994, 800,000. That's the Human Rights Watch estimate. Some say it's 1 million in 100 days. Bosnia and Herzegovina, former Yugoslavia, 1991 to 1993, 96,000. That was called ethnic cleansing. Cambodia, 1975 to 1979, 2 to 2.5 million. Some say most likely the figure is 2.2 million. Darfur, that's from 2003 and it is continuing, 300,000. So when one talks about massive killing, it is about many hundreds of thousands to millions. To suggest that an isolated event, which was most unfortunate, the most unfortunate murder of about 3,000 people in Southern Shatila, is the same as massive killing, is almost disrespectful to the true horror of massive killing. True horror means, for example, in Rwanda, 800,000 dead in 100 days. That is an average of 8,000 people per day.
Can I ask a question? I think in the partition of India, and I can be corrected on the figures, there were 1 million dead and 11 million displaced. That wasn't called a genocide, but would you call that a genocide? My question is not based on the number of dead. Sorry. Is it not intention?
Intention.
If we'll even take this case farther, suppose that the Israeli Defense Forces entered into Sabra and Shatila and killed all male children, and all males who were present in those camps. Suppose they killed 1,000, 1,500. I have no idea the figures. Is that not an act of genocide? If they wanted to eradicate part of that population?
Genocide requires a systematic policy. It requires a pattern. You have a
You
pattern.
answered that question, thank you.
Thank you. When we quote numbers, it goes towards the term massive killing. Is 3,000 massive? Because 1 million is massive, 6 million is massive, is 3,000 massive. The true horror of a systematic policy of genocide, for example, let's take the most obvious one, Nazi Germany. What does it mean to have a policy? It means to put people on a train. You corral them into camps. You separate them into lines to march to their deaths. You allocate them uniforms and you tag them with yellow stars or pink triangles to show that they are degenerates in your eyes, and then you burn them